In California, does your military service justify dismissing your misdemeanor or your felony criminal case in court? Today, we're breaking down how active duty members and veterans can have their cases dismissed under Penal Code 1001.80, including a huge 2025 expansion that includes most felonies. Stick around and I'll walk you through eligibility, paperwork, and the things that will kill your motion. And most importantly, what happens after graduation. This is your DUI/criminal defense lawyer, Patrick Silva, practicing in sunny Southern California. In this video, I'm gonna hit 8 points, and each is gonna be about a minute long. I will cover what is Penal Code 1001.80. Number 2, who qualifies for military diversion. Number 3, the 2025 felony expansion. Number 4, the causal connection. Number 5, disqualifiers. Number 6, the step-by-step filing process. Number 7, pitfalls and pro tips. And number 8, the most important, the benefits after graduation. Number 1, what is military diversion? It will allow a judge to pause your case for up to 2 years while you complete a court-approved treatment plan. When you successfully complete the plan, the case will be dismissed. You will never have even entered a guilty conviction. But if you fail, the prosecution is going to pick up right where they left off and keep prosecuting you. Number 2, who qualifies? Active duty members, reserves, and if you've been discharged honorably. What are a few of the qualifying conditions that were caused by your service? PTSD, traumatic brain injury, military sexual trauma, any type of substance abuse disorder, and other service-related mental health issues. What used to qualify up to the end of 2024, it was only misdemeanors. Number 3, the 2025 felony expansion. Under the 2025 expansion for felonies, most felonies are eligible, unless it's some type of crime where you have to register as a sex offender, or if it's classified as a violent offense, or it's classified as a serious strike felony. Here's a side note. Here's a quick story about one of my military diversion cases. We'll call him Johnny. It was one of my pro bono cases. So Johnny, ton of military action, ton of deployments into the Middle East, over a dozen situations where he ended up having to kill people. Guy was a mess. His 3rd DUI came to me, and we were able to help him. It took us a long time. It took well over 2 years, but we got his case dismissed. He ultimately got cleaned up, got a job, got a place to live. So that's what this type of military service can help. It could help those people that really need it. All right, let's get back on track. The number 4, the causal connection. It's not just good enough that you served in the military. There has to be a causal link between your crime that you're being charged with and your condition that you suffered because of your military service. Think of a battery or a bar fight, you're being charged. That could be causally connected to your PTSD that you suffered because of the action you saw in war. Or think that you're being charged with a DUI. That's causally connected to your alcohol dependency because of the stress and the PTSD that you experienced in the service. But the attorney can't just pay lip service. We have to prove it with evidence. We have to file a motion. My preferred method is I have you evaluated by a licensed clinical social worker. She will write approximately a 15-page report outlining your service and the connection between the crime and the disorder that you suffered because of your military service. Number 5, let's talk about some of the disqualifiers that will keep you out of military diversion. One reason that the judge could deny you into military diversion is that you have a prior case dismissed under Penal Code 1001.80. The next big one is, quote, non-suitable. I see that a lot where the judges will deny military diversion based on their interpretation that you are not suitable for treatment. Moving on to number 6, let's talk about the filing process. Step 1, you're going to want to gather your documents. You're going to need your DD-214 or your military ID showing that you are active service. A medical psych evaluation that ties your service to your condition to alleged crime, and a proposed treatment plan. As the lawyer, you want to already know what the judge likes. You come up with the plan if you're a lawyer. You devise what you think will work. What I've seen a lot of times, the judges go with our treatment plan because it's fair and reasonable. Step 2, we'll call this lawyer work. You're going to draft the motion. You're going to attach your exhibits like the DD-214. You might attach exhibits such as a character reference letter. You're going to attach your eval. So again, our licensed clinical social worker will attach her evaluation. And we will usually say that our client waives his right to a speedy trial because remember, you're stretching this out for about 2 years before it gets dismissed. Step 3, serve and file your documents. That means you're going to give the district attorney a copy. You're going to file them with the court. You're going to pick a date and then get ready for your hearing. I think the hearing can go one of 2 ways. It's going to be contested where you're going to have a full blown out boxing glove hearing, or it might just be, hey, attorney, defense, prosecutor come up to the judge's bench table and the judge is saying, all right, we've done this a million times. Do you have everything? The DA says, yep, everything's there. And it's by agreement. Johnny's getting into military diversion and here's the treatment plan. Usually that's where it's at now in the middle of 2025. Moving on to section 7, pitfalls and pro tips. The treatment plan can last between 12 and 24 months. You're going to have some type of court review. It might be monthly, it might be quarterly, or it might be every 6 months. But you and your client will show up. Judge is going to ask you, is he still doing the treatment plan? That simple, quick, in and out, that's a review. Depending on the type of charges, you might be doing weekly therapy or you might be doing random drug testing. If it's alcohol related, they might have you install a breathalyzer on your car, and they might ask for proof of your mental treatment if you are in therapy. That could be receipts or a letter from your psychologist, psychiatrist saying, yes, Johnny's still in treatment. And this is where most people screw up. If you fall out of treatment, you're gonna have a hearing. Usually the judge is not kicking you out of military diversion on the first screw up. I've seen in my experience, they usually give my clients 2 or 3, but there's a point when the judge says, all right, enough's enough. Send him back to criminal court, let him fight it the old-fashioned way. One of the main pitfalls that I see is that there's no connection between the crime charged, the military service, and the condition that your client suffers from. And let's get to number 8, the big payday. What happens when you complete military diversion? First of all, you never ever entered a guilty plea and your charges are ultimately dismissed. Remember, you never even said guilty. It's just dismissed as if the case never happened. Your gun rights will remain intact. Your voting rights will remain intact. If you're an RN or have a professional license, that will remain intact, or you'll deal with the board at that point in time. But again, there's no conviction. And now I'm going to answer my own question. Yes, I do think that our military members do deserve that free bite at the apple and to get their criminal case dismissed under military diversion. Patrick Silva, have a nice day. Out.